Choice of law was addressed in the U.S. Supreme Court case of Klaxon versus Stentor. This is a 1941 decision. It was unanimous, and the opinion was written by Justice Stanley Reed. Basically, what happened in that case is you had these two corporations, Klaxon and Stentor. Stentor was from New York. They transferred their entire business to Klaxon, a Delaware corporation. Stentor was supposed to have a share in Klaxon's profits. The agreement was executed in New York. Assets were transferred there, and Klaxon began performing there, although it later moved its operations to other states and performed duties and ostensibly breached those duties there. So Stentor sued in the district court in Delaware, that's federal Delaware court. Klaxon was incorporated there, so the court had personal jurisdiction over Klaxon, and it is a diversity case, so there's subject matter jurisdiction. Stentor originally got damages and then requested for interest to be added onto those damages that they won under New York law. This was New York practice. So the district court in Delaware applied New York law and granted the request. The district court thought that the proper choice of law rule was state law. They said New York is it, since it's where the contract was executed and performed in part, even though this is the federal district court in the state of Delaware. So this makes its way up to the U.S. Supreme Court, and the U.S. Supreme Court clarifies how Erie doctrine figures into all of this. So they say we apply Erie to choice of law. Erie, of course, was from 1938, so just very recently, and it's a doctrine about when we apply state or federal law. But this time we're dealing with different states. We're not dealing with state versus federal. So choice of law is horizontal. Conflict of law, which was addressed in Erie, is vertical, where you have, do we apply state law versus do we apply federal law? So conflict of law rules to be applied must be those used in Delaware state. So use the Delaware rules, not New York rules. No interest to be added if Delaware doesn't do that. And so they say the federal district court needs to apply the substantive law of the state that they are in, the state that they sit in. So if you're a Michigan district court, you're applying Michigan law. If you're an Alabama district court, you're applying Alabama law. Connecticut, apply Connecticut law. It's pretty freaking simple. A lot of people get really worked up about some of these Erie doctrine types of conundrums, some of these situations, but I feel like Klaxon just adds a little bit that's pretty simple to understand. Erie as a whole is a really fascinating thing when we deal with state versus procedural and the analysis of, okay, is this outcome determinative or not? But Klaxon, with these choice of law things, we don't really look at that. We just look at which state does this district court sit in? It's pretty easy to tell because it'll be in the name. Federal District Court of Delaware, we know that. So we say, okay, you sit in the state of Delaware, therefore we will apply Delaware substantive law, not New York. Let me know what you think of Klaxon. I hope this video was helpful to you if you're in civil procedure as a law student or if you're an attorney trying to learn more about some of these types of issues. I hope that you're able to take this and run to the bank with this, get a straight A+ in your civil procedure class in law school. Hope it's helpful. Like, comment, or subscribe to the channel. Thank you so much for watching, and I look forward to speaking to you in my next video.